Under the ethics rules, information relating to the representation is very broad. It includes more information than what is protected by the attorney-client privilege. It is broader than privileged information or client secrets. The comments to Rule 4-1.6 clearly state that the information includes all information relating to the representation, whatever the source. This means that even information the lawyer learns independent of the client's input, such as through investigation or from other people, is within the definition. And even information that is part of the public record is considered information relating to the representation. In other words, while you might think that information relating to the representation doesn't apply to information that is public or publicly known in Florida, it does. Information relating to the representation can be information that is publicly accessible in the newspaper, in a court record, or on a publicly accessible database. In other words, the information doesn't have to be actually secret or unknown to others to be subject to the lawyer's duty not to disclose it. What about the simple fact of a client's identity? The Florida Bar has said in at least 2 ethics opinions that the identity of the client is confidential information. So let's return to Raya. Did Raya disclose information relating to the representation to you in her party chit-chat? Probably so. Revealing the identity of the client and the nature of the deal, describing the client's motives and desires, describing the board members' attitudes, discussing company earnings, and revealing the plans and expectations of the company's leadership all fit into the definition. Even discussing information that appears in the news is information relating to the representation. While the knowledge is publicly available, the ethics rules contemplate that the client's lawyers won't reveal it. Thus, it's very likely that Raya should not have revealed any of this information to you. So this information was information related to the representation. But did Raya breach her ethical duty of confidentiality to WonderWorks by revealing it? Probably so, because there likely aren't any exceptions that would have made it ethical for Raya to reveal this information. The first exception has to do with harm to the client. That is, if Raya's small talk didn't harm WonderWorks, does that keep Raya out of ethical trouble? Probably not. There is no exception that places harmless disclosures outside the Florida confidentiality rule. While in some jurisdictions, only harmful revelations are prohibited, in Florida, harm doesn't matter. Any information, good, bad, or indifferent, relating to the representation is protected from disclosure. And if there's any doubt about whether information is protected, a lawyer should choose to stay silent. Is it possible that Raya's disclosures may have actually harmed WonderWorks? Consider this. Maybe you decide to call your friend Jim, who's on the other side of the WonderWorks deal, and tell him what you learned from Raya. Remember, you have no duty to keep the information you learned confidential. WonderWorks is not your client. Jim, knowing this information, might adversely impact WonderWorks' position in the negotiation. For example, if Jim knows WonderWorks is motivated to get the deal done, then Jim might be more likely to seek a more favorable deal for his client in a negotiation than if he did not know about WonderWorks' motivation to accept the deal. If that's the case, there's a good chance that Raya harmed her client by revealing this information. And if Raya's comments end up harming WonderWorks, Raya may have not only violated ethics rules, but she could have also committed malpractice or breached her fiduciary duties to her client. The next possible exception is anonymity. That is, would Raya have avoided ethical problem if she hadn't disclosed the name of the client? Well, perhaps this is a closer question. It's more likely that nothing changes in the analysis. Anonymity doesn't make an ethical difference. Florida's confidentiality rule does not have an anonymity exception that would keep a lawyer out of trouble for revealing client information that does not directly identify the client. While the Florida rule is silent on this point, a comment to the similar confidentiality rule in the Model Rules of Professional Conduct says The prohibition on revealing client information applies to disclosures by a lawyer that do not in themselves reveal protected information, but could reasonably lead to the discovery of such information by a third person. In addition, other ethics commentators have suggested that a lawyer may talk about client information only if it is virtually certain that the listener could not identify the client or the situation. So even if Raya had kept the name of her client out of the party chat, it's arguably not enough to avoid an ethics problem. Even if Raya avoided telling you WonderWorks' name, it would be simple enough for you to talk to Jim, share what Raya said, and discover the client's identity. Or given the information Raya revealed about the nature of the business, the land deal, and the press about the changes in company leadership, you could do a little internet research and likely discover the client's identity. Thus, Raya could not have been virtually certain that the facts she gave, even in the absence of stating the client's name, would not lead you to discover the client's identity. Even if we could make an argument that keeping the client's name out of it would make the situation different, there is no guarantee for Raya that this interpretation will hold up because there's nothing in the Florida rule, the comments to the rule, or any interpretation to the rule that suggests an anonymity exception exists. The last possible exception is about implied authorization. That is there a chance that Raya might have been authorized to discuss WonderWorks at a happy hour? Again, probably not. A Florida lawyer is permitted to reveal confidential information to the extent the lawyer reasonably believes necessary to serve the client's interests, unless it is information the client requires not to be disclosed. The comments to the rule say that in litigation, for example, a lawyer may disclose information by admitting a fact that cannot properly be disputed, or in negotiation by making a disclosure that facilitates a satisfactory conclusion. In Raya's case, there is nothing to suggest that her revelation served the client's interests. And one other thing, do the other people at the happy hour make matters worse for Raya? Probably so. When Raya was talking to you, she may not have been thinking that other people around her may have overheard the conversation between the two of you, but that very well may have happened, and Raya's difficulties with confidentiality would, in that case, compound. It's always best to assume that discussions in public places can be overheard. Not only are Raya's disclosures, at least some of them, likely an ethical breach under Florida rules of professional conduct, they are also unprofessional under the Florida bar's professionalism expectations. In Florida, professionalism and ethics are different but related concepts. The Florida bar defines professionalism as practicing according to the highest ideals and tenets of a legal profession. One important source for professionalism is the Florida bar's professionalism expectations. Among other things, those expectations say that lawyers must maintain and preserve the confidence and private information of clients, and that lawyers should avoid the appearance of impropriety and place the client's best interest ahead of the lawyer's interests. The Florida Supreme Court, on its own orders, guides lawyers to adhere to the professionalism expectations. The bar's professionalism expectations apply to Raya, so we need to consider them too. In whose interest is Raya speaking? It's hard to see how this conversation furthers the client's interests, but it might further Raya's interest to connect with you, to demonstrate her good work on behalf of her client, and maybe brag a little and impress you. It seems like Raya might be putting her own interests ahead of her clients here. And if you found yourself a bit squeamish as you listened to Raya talk, well, that response suggests at least an appearance of impropriety. That is, you sense Raya's apparent failure to observe the ethical standards which Florida says is unprofessional in its own right. Hopefully, you now understand that the duty not to disclose information related to the representation is quite broad. Perhaps the bottom line for professionalism is that the lawyer's loyalty to the client means treating the client's story as belonging to the client. The client's story is not yours to tell. except in service to the client, to further the client's interests. And there's not much of an argument that a client is being served here by Ryan's small talk. Good judgment and the utmost discretion should have guided Raya to conclude that, even if there was just a small chance an ethics complaint might result from this casual conversation, it is a better professional practice to not discuss client matters at a social event. Imagine how you might feel if your lawyer or accountant or doctor or psychologist was discussing your life or your business at a happy hour. Avoiding social discussions of client information, private or public, interesting or mundane, anonymous or not, will ensure both high levels of professionalism and ethics.